Good morning, everyone in the USA, and good afternoon to everyone who is in the UK or on some other European time zone, where I also am today, in London. It's great to welcome you to the latest virtual briefing in our Corporate Citizenship and Sustainability series. And today we're going to be talking about the many challenges of navigating ESG regulatory disclosure regimes in the UK, in the EU, and the USA, which is a common problem for so many of the members of British American business. And we've been running this series of events for a number of years now, and we are enormously grateful for the support of our sponsors who helped make all of this happen. The series sponsors are Debevoise and Plimpton, United Airlines, and EY. And we have an absolutely terrific panel today, expert panel, who are going to help to talk us through the issues. It always seems to me that this subject is one of those areas which doesn't get probably it's hard to get the kind of pulse racing of senior general managers, and yet remains critically important to the success and viability of their businesses. And so the people responsible for navigating the ever more complex ESG reporting regimes are crucial for those senior managers. So we've got a great panel, as I said, and to introduce them and to moderate the discussion, it's great to have with us today Brian Tomlinson, who's a managing director in the ESG practice at EY. So Brian, great to have you with us, and I'll pass to you.
Well, thank you so much, Duncan. A great introduction to some of the themes that we'll talk about today. Very good to be with you all. So we'll structure this discussion in a couple of ways today. We'll do about 35 minutes of overview here with our panelists, and then we'll try to open up for Q&A. A couple of different ways that you can ask questions to us here. First of all, you can put your questions in the chat at the bottom. You can also use the raise hand function, and then we can potentially bring you on to ask your question directly to the panelists. So choose either one of those, as we're covering a lot of content today. I just want to make some framing remarks around what we're going to talk about here. It seems that every major economy really does seem to have some sort of ESG regulatory initiative over the last 2 or 3 years. Now, those have largely focused on disclosure, as you'll note in the overview provided for the session, although there are some elements of the regulations which are not purely disclosure focused. Some are related, for instance, to incentives connected to investing in more green initiatives. Now, in relation to those disclosure-focused regulations, you see a lot of common roots. For example, a lot of the way in which regulators have structured the disclosures have really called upon the ESG reporting ecosystem that's been developed over the last 10, 15 years to provide the overall architecture of the ESG regulations themselves. So some of those, for instance, will be things like the Task Force on Climate-Related Financial Disclosures, the Global Reporting Initiative, the Sustainability Accounting Standards Board, which has now been folded into ISSB, and then things like the GHG protocol for the structure of your GHG inventory, and so on. So there's a kind of common root to a lot of these ESG disclosure regulations. However, they tend to vary by jurisdiction by reference to the underlying sort of policy ambition of the jurisdiction in question. So for instance, if we'll spend quite a bit of time talking about the EU has their Green Deal, which is about basically resetting the European economy on a sustainable footing over the course of the journey through till 2050, and in fact trying to reach net zero by 2050 but net zero by 2050 with intermediate goals on the way there. So therefore, EU policy ambition drives a more extensive disclosure regime than, say, by comparison to, say, the United States. So this really imposes a significant regulatory and disclosure burden on companies who are both incorporated in Europe, doing business in Europe, and indeed doing business in any of the jurisdictions which have some of these major disclosure regulations in place. So learning curve, lots of implementation challenges, lots of governance challenges, resourcing challenges, and so on. And we'll talk a little bit about those today as well after we've given you a bit of an overview of some of the most seminal pieces of regulation in place. So we've got an absolutely terrific panel today. Delighted to be joined by Thierry, who's the head of sustainability and strategic sourcing at Hearst Magazines UK. Great to have you with us. We're also joined by two speakers from Debevoise, Ulysses, who's ESG senior advisor at Debevoise, and by Patricia, who's a partner at Debevoise. So we couldn't ask for a better panel of speakers to talk through these themes. So with that bit of throat clearing from me, Patricia, I really wanted to get a sense of, or rather give the group here an overview of the nature of the EU regs that they're facing, particularly those CSRD and SFDR regs that are some of the most seminal pieces of disclosure regulation that the EU has put in place, and perhaps to provide a little bit of comparative perspective there.
Yeah, great. Thank you. Thank you, Brian. So yes, on the EU, as you also indicated in your introduction, is very ambitious about their EU targets, and so there is quite a bit of EU regulation out there that the industry has to deal with in practice, and I'll explain in a minute why this is very relevant also to UK and US companies, and not only to the European companies, because the EU is taking a pretty broad approach in terms of scoping. So what do we have? I mean, the most sort of important regulatory frameworks that everybody sort of has to know about, I think, and deal with at the moment is one. We have a regime that applies a disclosure regime that applies specifically to financial market participants. So in particular, fund sponsors that are marketing funds to investors in Europe will have to comply with certain disclosure requirements. What is important about this regime it's called the SFDR regime. And what is important under that, it's not meant to be a label regime. So you have different disclosure requirements depending on which category you would fall in. And that is very often by the market has been understood, or, you know, to a large extent being understood as a label regime. And that caused a lot of irritation and confusion. But in practice, it's not really meant that way. And the Commission is actually currently revisiting the regime. There might be further changes going forward in the next few years. And maybe the regime is going to develop more towards something like what we now have in the UK. The UK actually having proposed now, and that will become effective end of July this year, a regime where they actually say you as a fund sponsor, if you go out, you can choose a label. You don't have to, but you can. And if you do so, then they have specific labels like a label, just sustainability objective, sustainability improving funds, so the transition funds and sustainability impact funds. And then you need to have at least 70%. You know, you have specific product rules that need to fulfill certain criteria. So that is sort of the UK having gone that route of a label, and in addition, sort of a greenwashing rule, and where you use names in the brand ESG terms in the name of the fund. you have to comply with certain things. So that's sort of the UK, very much oriented towards you can choose if you want to, but if you don't have to. Whereas Europe, you can't really choose. If you're marketing ESG in your documentation as a fund sponsor, then you have to comply with certain disclosure requirements. And we differentiate between Article 6, 8, and 9 funds. And Article 8 is basically where you promote any environmental or social criteria in a certain manner. The law says you have to disclose on it on an ongoing basis and tell people how you're doing. That's sort of basically what is meant to be. So that's financial market participants. And then for all the rest, we have something called CSRD, the Corporate Sustainability Reporting Directive, which is covering all types of companies, so also financial markets, banks, insurance companies, also asset managers, also fund managers, not funds, but fund managers. And so under that CSRD, you need to comply with also extensive disclosure requirements about your own company, but also your subsidiaries, and in the value chain, your business partners, upstream and downstream. So quite extensive information. And I think sort of 2 points to be said on CSRD. There are many things to be said, but just to be short, one key element of CSRD is, one, it is sort of the approach of the double materiality. So you're not only disclosing information about the operations of your own company, how that could impact the value of your company. So it's not looking at it only from a financial perspective, but also you need to report on how some sustainability factors could have an impact on the environmental or the society more generally. So that's the so-called double materiality approach, which is different from the ISSB approach, for example, that you have in the rest of the world and also in the UK. So the UK has indicated they will go the route of ISSB, which is also sustainability disclosure, but not the double materiality. And the other important aspect under CSRD, it's public. So any company that is within scope, so meets the threshold, it's not any company that you need to meet certain thresholds, and I can talk about the thresholds later, but it's 250 employees and 50 million in turnover and 25 balance sheet. And then there are different sort of thresholds for different companies, and listed companies are always in and so on. But if you are in scope, the important thing is you need to prepare that report as of a certain date, and that report will be public. So the report will be publicly available to all stakeholders. And again, that is something to be borne in mind, quite important also in light of another directive that is going to come, we'll talk about later, the CSDDD, which is the Corporate Sustainability Due Diligence Directive, that will go beyond disclosing, that will impose obligations to implement certain procedures and due diligence obligations. But that in a nutshell is where we are. So CSRD, SFDR, and in the UK, the sustainability disclosure rules for the financial markets, the label regime. But then we also, for CSRD, we will get something under ISSB, a similar reporting regime. And of course, we have in the UK also TCFD, climate change related reporting obligations that already apply also today, entity level and product level for any regulated firm in the UK, and any listed firms exceeding a certain threshold, and insurance companies and pension schemes. So
no, that's terrific. That summarizes an enormous amount of material in a very brief period of time. And it does actually, I think, point to the way in which the suite of EU policies kind of knit together, right? Which is, if you're going to have something like SFDR talk about the way in which institutional investors have to think about how they are badging their funds and how they're thinking about portfolio companies within those funds under SFDR, you then have to get companies disclosing relevant information to allow the institutional investors to make those allocations. So essentially trying to knit these two things together. And it does also point, I think, to the scope of the overall ambition of the Sustainable Finance Action Plan, which, yes, has things like SFDR and CSRD, but also has things like adjustments to fiduciary duties, a green bond standard, sustainability benchmarks, and so on. Really a kind of full court press in terms of trying to deploy finance in support of those broader sustainability ambitions. And maybe just again to add on to your great comments on CSRD is to just note the extensiveness. You know, there are a load of standards out there that have been developed. The standards that the EU are using are by far the most extensive in terms of the amount of the ESG spectrum covered, the number of data points, the amount of disclosure, the novelty of those disclosures, and so on. And often binding companies, not just who are incorporated in the EU, but who do business in the EU. So they may have significant extraterritorial effects as well, which is something that we're finding with many of our clients who are scoped in to CSRD. And again, as part of that broader EU ambition, the EU isn't just thinking about sustainable impacts that occur in the EU area. It's also thinking about value chain, to Patricia's point. So you're often thinking about impacts under that impact materiality construct that may exist way outside the EU's borders as well, because ultimately the EU is interested in impact no matter where they occur, which I think is an interesting construct and something of an expansion in the way in which ESG disclosures, certainly in the regulated context, have worked to date. So hopefully that gives... Yeah, and Patricia, please.
Sorry, just to sort of that, because that's an important point. Even if as a company within the EU or outside, as you said, but also within, you determine you're not in scope, you think, you know, my God, I you know, sort of not covered. That is still sort of going to be relevant because you might be a supplier, you might have business partners, you're likely to have business partners who are subject to this, and these business partners will be required to impose certain of those requirements on you in their contracts. And to the sort of non-Europeans, yes, indeed, CSRD actually does not directly apply to non-European parent companies other than CSDDD, but CSRD drags them into, as of 2028, if a non-EU parent has an EU subsidiary that is within scope, and altogether they generate, this non-EU parent generates 150 million in the EU and revenue, it will sort of be dragged into a consolidated worldwide report, including all subsidiaries, not only the European ones. So just that's, you know, that's why it's so relevant to everybody.
Yes, I've heard this called the Brussels effect on steroids, which I think would not be an inaccurate description. And again, just to note, just to double click there, that there have certainly been lots of instances of companies that we've spoken to where they are scoped into CSRD in ways that were unanticipated, and so has quite a significant impact in terms of the amount of readiness work to be done to get ready for that regulation. What I would say before teeing up Ulysses is that one of the things about CSRD is that it is so extensive. So it is the most extensive disclosure regulation out there because of the amount of standards that it incorporates into it. So it is, I think, one of the hardest to get up to speed with, particularly for those companies that are scoped into it who aren't necessarily based in Europe in a meaningful way. So with that on the EU and that Green Deal, Ulysses, I wanted to ask you to give us a sense of how that compares to some of the regulatory efforts in the US, what those look like. I know we had a long wait for an SEC proposal to turn into a rule. That's subsequently been parked. We also have some state level initiatives. Can you give us a sense of what the US picture looks like right now?
Yeah, gladly. And thanks, Brian, for that. And thanks to Duncan and BAB for having us back. It's always a pleasure to be with you. And these are amazing, really productive, fruitful discussions. So thanks for being a part of it. So I suppose, unsurprisingly, ESG disclosure, as in the US, as with so many things, is, I think, quite a bit more muddled picture, I would say, overall than what you see in Europe. And partly going back to your opening remarks, Brian, I think it may be the fruit of a lack of policy consensus in the same way that you might have the Green Deal in Europe, lacking that kind of policy consensus in the US on sort of the overall direction of travel on climate and these issues may be sort of the origin for this more muddled picture. So probably the most significant development, I think, over the last 6 months is, as you say, the issuance of the final SEC climate disclosure rule. Yes, we waited a couple years for the final version of that. The level of response from the business community and others was unprecedented in the sense of getting something upwards of 15,000 comment letters in response to the proposed rule. And the ultimate goal, in the words of Chair Gensler, with this disclosure regime, was to create consistent, comparable, and reliable information for investors, shareholders, other stakeholders on climate. That is the stated goal. And so, the final rule was significantly, I think, scaled back from the proposed form. It nevertheless would still be a quite transformative change to the U.S. sort of approach to the securities regulations and disclosure, and a significant expansion of the disclosure regulation. So I'm going to give just a few minutes sort of the main elements, if that's okay, because there's California and others to talk about. But just to be clear, in the context of the SEC climate rule, it applies essentially to public companies, to SEC registrants, those who file, Form 10K annually, and foreign private issuers. So the scoping, I think, there is important, particularly in comparison to some of the other frameworks that I'll talk about in a minute. But really, I think, again, as you said at the top, Brian, there are sort of common sources to, the SEC's ultimate rule. The TCFD was obviously an important reference point. The GHG protocol was an important reference point for the SEC. And so there are, a number of kind of common features, even to the CSRD and others that Patricia was talking about. I mean, essentially what the disclosure requirements will relate to are things like, the board oversight of climate risk and sort of what the board is sort of, capacitated to do. What are the processes and approaches that the board is taking? What is the sort of the capabilities of the board when it comes to climate risk? Management oversight. There are disclosure requirements related to management oversight, disclosure requirements related to the material climate-related risks and opportunities. So, the materiality point that Patricia highlighted with CSRD is quite important in the SEC final rule. It takes a more traditional US-oriented, SEC-oriented financial materiality approach, where you're filtering many of the disclosure considerations through the question about whether it would really matter for a typical investor in terms of making investment decisions. Is it material in that sense, as opposed to the double materiality approach that the CSRD has adopted? But so yeah, material climate risks, material climate impacts to your operations, to your strategy, to your various stakeholders. There is a GHG emissions component to the disclosure requirements. This is an important area where the final rule diverges from the proposed rule. The proposed rule did include Scope 3 greenhouse gas emissions where material. In the final rule, that requirement has been omitted, at least in a direct sense, and focuses really on Scope 1 and Scope 2 greenhouse gas emissions where material, and limited to sort of the largest public companies. Smaller public companies are excluded from that requirement. There's disclosure related to kind of risk management and transition planning. There are disclosure requirements related to the use of things like carbon offsets and renewable energy credits. To the extent that your organization has a net zero or a climate transition plan, there's also sort of materiality considerations there. There are disclosure requirements that apply. And then there are a range of different kind of financial disclosures that would be included in a kind of separate financial statement that would relate to things like natural disasters or different climate impacts on different financial aspects of your operations. I think just a couple of things to kind of pull out just to note. There are attestation requirements on a phased-in basis that will apply to these. So, I think that's something in terms of the implications for the governance around and the processes for gathering this information and disclosing it in a sort of comprehensive, accurate, verifiable way. There's some significant implications there. And then there's a fairly robust sort of timeline for these requirements as they'll phase in. You mentioned, Brian, the fact that the legal challenges came fast and furious to the final rule when it was issued. In fact, I think the first filing happened on the exact day that the final rule was issued. 15 or so other challenges sort of came and followed. And just to give you a sense of kind of where things are at currently, the cases have all been kind of consolidated into the 8th Circuit in the US, and the process is sort of proceeding apace. But the SEC issued a voluntary stay of the rule. So at the moment, the rule is stayed while the legal challenges play out. Obviously, there may be questions, we can come back to that, but I think it's important to highlight the California climate regulations that were signed into law last fall. These are also quite significant. I think in the US, they apply not only to public companies, they reach private companies as well. So everything from accounting firms and law firms and private equity firms, if they sort of meet the thresholds, could be subject to these laws. I think, kind of in a general sense, you have a law, SB 253, which is basically a disclosure law that relates to greenhouse gas emissions. The requirements here relate to scopes 1, 2, and 3. So scope 3, emissions will be required under the California rule. The revenue threshold, the thresholds of application there are essentially if you are an organization that does business in California and have annual revenues globally of above $1 billion a year, you are in theory in scope, although it's important to note that this year, the California Air Resources Board, the regulatory body that will be implementing this law, is developing implementing regulations. So we'll see, how some of these aspects are qualified or changed. There's a law, SB 261, that focuses on basically, reporting out climate-related financial risks and opportunities, essentially kind of providing a TCFD-like report. And then the third law worth highlighting, which is actually one that is currently in effect, AB 1305, which relates to essentially the use of voluntary carbon offsets and kind of net zero claims or carbon neutrality claims. And that is a law that I think a lot of our clients are kind of thinking through and sort of dealing with now, because as I said, it's of the ones we've talked about so far in the US, it's the one that really currently is in effect. So maybe I'll stop there and pass it back to you, Brian. I know that's a lot to take in, but over to you.
But it's a great overview of a really mixed picture. And I think actually, if you compare the US to the EU, I think one of the notable features is that in the US, you do have fine SEC rule, California pro ESG. You also have a state picture across the various parts of the US where you have an anti-ESG push as well. And I wonder if you could spend maybe a minute or so to just describe what that looks like at the moment as well.
Sure. So these are, the kind of anti-ESG laws that we've seen are, largely, they're not so much disclosure related. They actually are seeking to kind of govern behavior, which is sort of a different approach. But, essentially there's a lot of variance. And just to kind of pick up on the earlier theme of, just kind of the fragmentation and the complexity of the differences between these different regimes, even within the US, within the US at the state level, and even within the anti-ESG states, there's a lot of sort of variance between the different approaches. But, broadly speaking, the anti-ESG laws, for lack of a better term, kind of fall into two main buckets. One of them really is focused on essentially strategies that financial services firms and private equity firms might deploy that result in excluding certain industries. So these are called anti-boycott rules, and you see these in places like Texas and Oklahoma and Virginia and Florida, West Virginia and Florida, where essentially if you are a firm that might have a strategy that avoids or excludes investments in oil and gas or firearms or coal or the like, state entities, state contracting entities, pension funds, you name it, are prohibited from basically doing business with you. And so, we've seen over the last year blacklists sort of being put together by different states that identify asset managers or other firms that the state can't do business with, and that's gotten a lot of profile. The other kind of main category of anti-ESG laws are ones that really target consideration of ESG factors in investment decisions. So if you are a fiduciary to a Florida state pension fund, for example, if you're managing their assets, there are restrictions on how and in what way you can consider things like climate change, the diversity of a board, human rights issues in the investment decisions that you make. And in many of those laws, there's a little bit of a carve out or a caveat that's important, which says, except to the extent that doing so results in pecuniary value. So if you're thinking about investing in a real estate asset in Miami Beach and you're thinking ahead 20 years and sea level rise and the effects of climate change, and you're thinking about how that could affect the ultimate value of that asset, that is in theory acceptable, but it definitely puts significant limitations on how you approach and think about or use ESG ratings and the like. So yeah, it is quite a fragmented picture. And just to say, California on the pro ESG side is obviously not the only state that's moving in that direction. You have similar laws under consideration in places like New York and Connecticut and Massachusetts and Illinois. So yeah, a muddled picture, I guess, to say the least.
Well, it's a great summary, and it does point to the fact that obviously in the US you have to observe the federal intent in relation to policy, but then you also have to observe the state intent in relation to policy. In which states do you do business? How may that affect the way in which you are and are not able to operate? But then also balancing that against the other jurisdictions in which you operate and comparing the relevant ESG disclosure regulations that you are subject to. And I think that's an important point for us to maybe flex into some considerations around implementation and preparedness. Because many companies will be scoped into many of these different ESG disclosure regulations. So how do you start to get ready for this? This is a dominant part of our work with many of the companies we're working with right now. Now, in many ways, there's a natural flow of work in relation to readiness, in relation to these initiatives. So a lot of it will begin with a regulatory scan. So which regulations are we scoped into, where, and when will they have effect? There's often then the second order discussion, which can be very strategic in nature, beyond compliance, really, which is where are we going to report? In what way are we going to report on this regulation? Because as these regulations interlock, you have to think about the ways in which the disclosures you're making in one may map against the disclosures you're making in another. And then once you've done some of that initial preparatory work, you're then thinking about doing things like a gap assessment against, well, what's our current ESG stance today? What are we disclosing? What type of disclosure is the regulation going to impose? And then how do we then respond to that? How do we then build what we need to build to get ready? And following on from that, often you'll see companies setting up pretty accelerated, given the compliance windows of a lot of these regulations, roadmaps to start themselves on the journey to readiness. So just to give a flavor of the way in which some of this can be structured. So with that kind of overview of both this full court press of ESG regulation, and some of the ways companies are starting to structure and respond to these regulations, Thierry, I think this is a great opportunity for you to give a little bit of detail on Hearst and some overview of some of the steps you've taken to start getting ready for the relevant regulations you're scoped into.
Thank you, Brian, and thank you, Duncan, for inviting Hearst UK to this great panel. So, so we are Hearst Magazine UK with about 700 employees and 20 brands such as Cosmopolitan, Hair Lover's Bazaar, Men's Health, Women's Health, Good Housekeeping, Country Living, to name a few. At Hearst UK, so as part of the large organization with an international footprint, we see different expectations on sustainability reporting from both external and internal stakeholders today. So by external, I mean legislations, audiences, clients, suppliers. By internal, I mean leadership and employees. And so at Hearst UK, of course, we will produce our sustainability reporting based on the UK legislation, using the IFRS standards focusing on financial materiality. However, due to our sister companies in the EU, Hearst Netherlands, Hearst Spain, Hearst Italy, and our EU clients, we are keen to follow the sustainability assessment framework with double materiality, anticipating that impact materiality will enhance the quality of the mandatory financial materiality. So how do we get ready? So I'm going to give you 7 examples, focusing on current state assessment and stakeholder engagement, as we are not yet on the impact, risk, and opportunity review. So first, we are coordinating with our statutory account auditors to include the sustainability reporting for the 2025 financial reporting. We have participated to various webinars, including a Great United Nations Global Compact and a GRI sustainability reporting training, which prepare for double materiality assessment. We discuss our journeys and difficulties with our peers and through the UK Publisher Association, and also with the UK Advertising Association, our client partners. We have started to engage with Hearst UK senior leadership, starting with legal, finance, but also super important PR and comms, to produce the initial sustainability assessment based on CSRD. In terms of preparation, we have finalized early 2024 our full carbon footprint, according to the Greenhouse Gas Protocol, of course. And we are almost finalizing our SBTi near-term target commitment. Our goal for 2024 is to train all the relevant team members to accurately collect data in 2025 in preparation to the initial mandatory reporting in 2026. And last, so we are in discussions also with our auditors about the recommended internal organization, time required, and the forthcoming annual SDS reporting, and all the associated costs. So that's where we are right now. So kind of, we want to do things the right way. So we don't want to rush in a wrong direction. But we've heard on so many consultancies and webinars that we have to start now before the final regulatory procedure being published. So we're started, and I think that we are in a good position to be on time with a good reporting.
Well, that's great, Thierry, and that reflects, I think, quite a lot of what we've seen from our clients today. I mean, a lot of these regulations, though they're based on the existing reporting ecosystem, they often adapt that reporting ecosystem when they've incorporated it into the regulation. So there's a lot of awareness raising, a lot of learning, a lot of training to get people up the curve. I also thought it was great to hear you reference that peer learning from your industry peers, because I think that's going to be a really important way for companies to proceed. particularly in the ESG space where, material ESG issues vary systematically by sector. So, the issues of one group of companies in one sector are likely to be quite similar to the issues, are likely to be very different from issues of companies operating in another sector. One thing that we are seeing other companies focusing on is also because these ESG regulations are essentially kind of being bootstrapped to the level of financial disclosures. There is a pattern of many companies hiring things like an ESG controller, which is essentially a person in the finance function to oversee the disclosure of ESG, to apply that kind of finance process and control lens to ESG reporting. So that's a real pattern that we're seeing across the industry. Patricia, go ahead.
That's a great point, Brian, because that's one point I wanted actually to make is, as you both said, there is a lot of learning to be done at this point because we're all sort of living with CSRD and ESRS, the reporting standards, to a large extent not yet being available and so on. But in particular, as you quite rightly, Brian, said out the sort of steps that you now need to do in terms of getting ready for CSRD, and where you start with is really the scoping exercise. So what entities in my group could be within scope, or are we as a group within scope? And very often, as you also said, Brian, it turns out that, unintended, you end up being in scope because, for example, you have a common holding company, and through that holding company, you have to aggregate the numbers and then exceed the thresholds. And so that's then sort of the unintended surprise in here. You have to comply with all of this. So it's important to talk to people and go through that scoping exercise, but there is a lot of interpretation to be done because the rules are not always so clear. And obviously, to go the easiest path of least resistance is really always looking at the financial. Is there financial consolidation? Is there financial reporting? Is there sort of an exemption in the accounting directive available for financial reporting? So that absolutely makes sense, and we do that as lawyers as well. But I think it's important to involve the lawyers in this exercise because at the end of the day, these are laws, and sometimes there is a different interpretation possible, and it does not necessarily have to always follow the financial accounting perspective. I mean, in many cases it will, but not always. And so I guess what I'm saying is it's important for lawyers and accountants to talk to each other and find sort of solutions that actually work for the industry, for everybody, because some of the things you end up, looking at it and say that can't possibly have been the intention of the legislator, and so we need to interpret and come around some way that works. And that's a phase. It might be frustrating for clients sometimes, but that's a phase we're in right now. And through industry associations and talking to each other, we're getting there. But that's, as always, with a very sort of law that quite substantially is changing the landscape, that's where we are right now. And it's important to go through that exercise.
Yeah, so strongly agree with that. I mean, there's, the ESRS standards are what, several hundred pages. EFRAG is now, which is the body that developed those standards, has issued 3 sets of interpretive guidance on them and Q&As. So as with any novel piece of regulation legislation, there's certainly interpretive space within those standards. So it's good to have your advisors aligned when navigating those. And again, just to pick up another one of Thierry's great points is just the importance, given that these disclosures are largely going to be assured. Some of the phase-ins, some of the assurance requirements are phased in, some of them are not. So for instance, in relation to CSRD, the disclosures, the phase-in, there is no phase-in in relation to assurance, unfortunately. In early engagement with your auditor to bring them along with you, I think is an important part of that process. And just Thierry, just maybe to go back to you made a few points about how you've been getting ready. Are there any particular challenges that you have faced in terms of that readiness effort? Because we're seeing that the challenges exist all across the board. It'd be just an interesting sense to get a sense of any challenges you've specifically faced.
Yeah, well, as a sustainability experts and feeling the sustainability, I feel that this exercise is super powerful to understand our business and kind of give guidance where to invest our energy, our money, our products in the future with reduced impact on the environment. And this sustainability reporting are firstly driven through compliance, so legal and finance. When all this hard work that we are doing to do the materiality assessment, I feel that and that's what we do at Hearst Magazine, we want to include the comms to kind of democratize the output of this materiality. So the employees understand what we do, learn something from what we do, but also our external stakeholders, starting with the suppliers, because we're going to ask a lot of information, lots of participation from our suppliers. So I think it is important that we communicate with them. Same with the clients, because our clients are also engaged, not necessarily at the media buying level. So we want to raise the awareness also through this media buying level of partnership with what we do. So I would say that my challenge is to move from this compliance side, legal and finance, to something more accessible by everybody. As again, this exercise is an incredible work that has not been done before. So let's make it, public, and let's make it shared with everybody. So that's, I would say, my challenge internally to move from the compliance to something more strategic and a communication tool with all the stakeholders, which are not the legal and the finance again.
That's right, because a lot of these disclosures, I think, will inevitably have strategic effects for your business, reputational impacts, how you're perceived, ratings impact, and so on. So seeing it as a kind of whole firm concept and bringing everyone along, I think, is going to be important. We did have a couple of questions in the chat, Ulysses, Patricia. One was on whether the disclosures under the SEC and the UK would be public. Could you guys respond to those?
Apologies. So the sort of equivalent to CSRD in the UK, which would be ISSB, that is not yet. We don't have a draft yet, so we don't really know whether that's going to be public. Sort of my personal expectation would be that it will be public, like any financial reporting, but I don't know is the answer, how this is going to be in the UK, and defer to Ulysses for SEC.
Yeah, so SEC filings are accessible by the public. They're made available on the SEC's EDGAR website, and so you can go onto that website and pull a Form 10K or whatever for any public company that's there. One thing just to mention on California, it's not completely clear what the disclosure requirements and where things will be disclosed is. This is the California Resources Board that I mentioned will be sorting that out, but that the law that I mentioned that's currently in effect, the one that relates to voluntary carbon offsets and neutrality statements, that is the requirement there is really for posting the disclosure on a website on the firm's website. So those are also public, and I'm sure that the California reporting disclosures will also be public.
That is terrific. Thank you for those. And excellent. We gotta thank you for the answer. So appreciate that. We've got a few minutes left, and Patricia, we did talk about giving a little bit of an overview on CSDDD. I think that's an important one for us to maybe briefly cover, because it is perhaps slightly different from CSRD in a way, in terms of the extent to which it seeks to dictate behavior, the amount of obligations that imposes on companies scoped into it. Could you spend a couple of minutes giving us an overview of that regulation? Because I think it's also one of the most recent ones that has passed the EUG process, as well as part of the Green Deal.
Yeah, and even, thank you, Brian, and even more controversial than CSRD. So there have been many drafts in the legislative process exchanged, to a point where people were even hoping it or thinking it might not come. But it was adopted last month, so at end of May. And we're expecting it to be published within the next few weeks this summer. And so as of then, since this is a directive, there will be 2 years within which the member states have to implement it into national law. So we're talking about, some time, so it being applicable 2027, a few years away. But yet important, really important to already also start your scoping exercise, like for CSRD, and check whether you are in scope. The scope is not identical to CSRD, and the difference here, as I said in the beginning, is quite interesting. CSRD, as I said, as of 2028, can drag a non-EU parent company into scope by obliging the EU subsidiary to provide a worldwide consolidated report, albeit probably under simplified standards, and we're still hoping that ISSB might be recognized by then. But so it's only indirect, whereas CSDDD, the Corporate Sustainability Due Diligence Directive, which is, again, not about reporting, it's about having a due diligence procedure in place that checks whether there's anywhere in your operations a risk that you have an impact on environment or society. And if there is, have you identified it? Have you mitigated? Have you prevented it? And that's not only for you, but also your subsidiaries. And again, we have the value chain. So you're looking at your business partners, direct and indirect, actually, sort of having arrangements with them in place to make sure they are aware of it and reported it and mitigated. So that's really what this is about. And so one thing important for non-EU, it is directly applicable to non-EU companies that that generate more than 450 million in the EU in turnover, either on a standalone basis or as a parent of a group. So if you are a parent, UK, US parent of a group, then you need to look worldwide whether you generate in the EU 450 million. If you do, you are in scope as a group. So that's important to bear in mind. It will directly be applicable to you. And then I think the other aspect why I think it's probably even more controversial than CSRD, because it has more teeth. It actually provides for a liability regime. So it permits stakeholders to actually go against the company if it can show that the company did not identify, but could have identified, or did not mitigate or prevent a harm. It will not be sued for any harm caused by business partners, so that luckily went out. Also, no personal liability of the directors, but the company as such can be liable. And that is, obviously an important instrument that people need to be aware of, and that makes people quite nervous. That's sort of in a nutshell about this CSDDD. And again, Brian, as you said, for CSRD, first step is scoping exercise. Are we in scope? And then next step, sort of a gap analysis, or how do we want to approach it on a standalone group basis, and sort of do a gap analysis. That's really where you need to be.
No, agreed. I think the implications of this one, I think, are quite significant and will require a little bit of thinking through. We did have a great question just come through in the chat in relation to member state transposition. As many of you will know, obviously a directive, in order to become effective, has to be transposed into the law of each and every member state of the EU and indeed EEA members. Generally, what the directive is seeking to do is to harmonize at the EU level the approach to sustainability due diligence. So in relation to adverse human rights impact, adverse environmental impact. So member states aren't really allowed to subtract from a directive, but they are allowed to gold plate a directive, so to potentially make it more onerous rather than less onerous. We've seen a real mixed picture in terms of member state transposition in other directives, but we tend to see the more onerous the directive, the less likely there is to be gold plating largely. So good to look at that. Yeah, please.
And they agree with that. And this directive is so complex that I would personally actually be surprised if there were a lot of gold plating or even any gold plating. We have in France and Germany, and I think in the Netherlands, already supply chain, loi vigilance and so on. We have similar acts already in place at a national level, but they're not going as far as CSDDD, and they will be amended and sort of to when implementing CSDDD. So you will not see both of them being applicable.
In the final minute, just before I hand back to Duncan, I would say that as part of CSDDD, you also do have the requirement to have a Paris-aligned transition plan. So alongside all of those due diligence obligations, you also have that transition plan requirement. CSRD says if you have a transition plan, you have to disclose it. If you don't have a transition plan, you have to tell us that too. What CSDDD says is you have to have a transition plan and you have to tell us how you're going to implement it. And just to finalize, I suppose that the takeaway from all these points is, yes, these regulations are a compliance exercise, but they're also a huge strategic opportunity for your business, because these disclosures are going to say all sorts of things about environmental impact, social impacts, and so on, how you're going to respond to those, bringing everyone along from the C-suite down, very important. And again, to Patricia's point, making sure you get started with that. Where are we scoped in? How do we prepare? What are our gaps? What's our roadmap? And really prioritize those most difficult issues for getting ready. Because again, these disclosures, their extensiveness will present a real range of implementation challenges, even for the most sophisticated companies. So I hope that was a helpful rattle through a huge set of regulations. Thanks, Duncan and team, for convening today. Back to you.
Well, thank you, Brian, and thanks for moderating the conversation so brilliantly. And just a couple of things occurred to me. The point you just made and that Thierry raised is, for corporates there's obviously an obligation now for corporates, but it has to be more than just a reporting exercise. If the work being done on recording and reporting doesn't align with a overall strategy of the business, then you're going to have kind of dissonance inside organizations. The second thing is just going back to the wonderful understatement that Ulysses started his comments with, that there are the political issues in the US are not really settled. I mean, I think that massively understates the challenge in the US. And my sense is, given what the politics recently in Europe, is that we haven't reached the end of that story in Europe either yet. So I think it's going to be a bit of a bumpy road over the next few years, one way or another. But meanwhile, companies will just get on and do what they have to do. So with the support of great organizations like EY and Debevoise, no doubt. So thank you very much for being wonderful panelists today. And more to come on this subject for British American business members as we continue our series. But meantime, thank you all very much indeed.